Welcome to Easy Learning. Exercise number 5. The assessing officer had also asked Bill to provide details of depreciation claimed on the assets transferred by Ball and documents in support of the written down value of the assets. Bill, along with the reply dated 15th November 2010, had enclosed copy of the SOA. Assessing officer had also raised a specific query as to the basis on which the assets have been transferred, to which an undated reply was given by the petitioner. The petitioner has also stated that a note on the factum of demerger of assets by Ball and transfer to Bill, and the fact that it was without consideration as mentioned in the SOA duly approved by the High Court, was furnished to the assessing officer by producing and filling on record both SOAs and the orders passed by the High Court, which was taken note of and considered. In the aforesaid factual background and the legal position elucidated, it has to be held that Bill had made full and true disclosure of material facts, that is, all primary facts which are mentioned and stated in the reasons to believe. Nothing was concealed, withheld, and nothing was left to be factually discovered in the form of material mentioned in detail in accounts and other evidence that was not disclosed oblique stated but could have been discovered by due diligence. In fact, as noted above, reading of the reasons to believe, that is evidence and material in form of facts and figures, were duly stated and mentioned in the affidavit of 12th February 2010 opposing the second scheme of demerger and transfer of infrastructure assets. Facts and figures in the reasons to believe are similar, if not identical. In view of the aforesaid discussion, the writ petition has to be allowed as the jurisdictional preconditions in the form of proviso to section 147 is not satisfied in the facts of the present case. Explanation would not apply as all primary facts were disclosed, stated, and were known and in knowledge of the assessing officer. Further, this would be a case of change of opinion as the assessee had disclosed and had brought on record all facts relating to transfer of passive infrastructure, its book value, fair market value, as was mentioned in the SOA, as also that the transferred passive assets to become property of Bill, including the dates of transfer and the factum that one step subsidiary was created for the said purpose. These facts were within the knowledge of the assessing officer when he had passed the original assessment order for the assessment year 2008/9 on 20th December 2010. The writ petition is accordingly allowed and writ of certiorari is issued quashing the notice for reassessment dated 31st March 2015 issued under section 148 read with section 147 of the Act for the assessment year 2008/9. Writ of certiorari is also issued quashing the order dated 23rd February 2016 passed by the assessing officer rejecting objections filed by petitioner. In facts of the case, no order as to cost. Full stop.